Hey there, Louisiana Estate Planning Attorney Paul Rabalais here, and in this video we're going to explore whether a handwritten will in Louisiana is valid. All right, so here again, emphasize in Louisiana. I have reviewed the will validity laws of all 50 states, and there are many states, roughly half, where a handwritten will under no circumstances is valid unless it's witnessed and notarized, but a will that someone sits down and handwrites by themselves with no witness, no notary, in many states that's not valid. In some it is, and in the states where it is valid, the different rules apply. So really don't rely on this advice if you're not domiciled or living in Louisiana. This is a Louisiana specific rule. So in Louisiana, if you follow the rules, a handwritten will is valid, and we call it. There's two kinds of wills in Louisiana. There's what's called a notarial testament. I'll have another video on that, but that's the one that's all typed up. Has certain language in it called an attestation clause that makes it valid. It's notarized by a notary. It's witnessed by two people. It's signed on every page. That's one form of will. That's the most common form of will, is a notarial testament. But in Louisiana, a handwritten will, if it meets the validity requirements, is a valid will. We'll get into in a minute whether it's good enough to just have a valid will, but that's all we're talking about here for the moment. So in Louisiana, two kinds of valid wills, or testaments as they're called, a notarial testament and a handwritten, or what's called holographic testament. So I printed out just so I could give you the precise wording of the statute. I'm going to give you the statute. I'm going to give you a little commentary, but here we go on the validity requirements for an holographic or handwritten will or testament. All right, so the statute says that an holographic testament, which is a handwritten will, an holographic testament is one entirely written, dated, and signed in the handwriting of the testator. So if you're thinking about, doing your own kind of do-it-your-own will and doing it in your own handwriting, it needs to be written, dated, and signed in your handwriting only. I would not let anyone else's handwriting appear on that paper. It is done exclusively all in your handwriting. Don't do a handwritten will with your spouse. You have to have your own will entirely in your handwriting, even the date. And it's got to be signed by you. So all in your handwriting. And then it says, although the date may appear anywhere in the testament, the testator, and the testator is the person writing the will. Although the date may appear anywhere in the testament, the testator must sign the testament at the end of the testament. Date can go anywhere. I've seen all types. I've seen people write out September 19th, 2021. I've seen people put 9/19/21 to represent September 19th, 21. If it were me, I'd probably write out the word September 19 and then comma put 2021. So that can be anywhere in the testament, but the testator, the person making the will, must sign the testament at the end of the testament. Not good enough to sign it up at the top. Signed at the end of the testament. And then it goes on to say, if anything is written by the testator after his signature, the testament shall not be invalid, and such writing may be considered by the court in its discretion as part of the testament. So when I've seen so many handwritten wills, if you're going to do it, and there's a question whether you should do it, all in your handwriting, write out all the provisions, sign at the end, and then if you say, you know what, I forgot something, I want to leave that plant, over my left shoulder to Aunt Juanita. Then don't write that after the signature. Probably should write a new will, because you don't want to give a court, you don't want to do something where a judge can use their discretion to determine whether it's valid. So anything written after the signature doesn't make the will invalid, But as it says, such writing after the signature may be considered by the court in its discretion. So eliminate all of that discretion, put everything before the signature. Okay, keep going. The holographic testament is subject to no other requirement as to form. I think what that sentence screams is you don't have to get it notarized, you don't have to get it witnessed. Having it notarized doesn't make it a more valid will. Getting witnesses, getting one witness, two witnesses, three witnesses to sign as a witness doesn't make it any more valid as a result of the statement that, or the part of the statute that says the holographic testament is subject to no other requirement as to form. Again, this is a Louisiana statute only. If you're in another state, check that state's rules. Okay, then it goes on to talk about the date. The date is sufficiently indicated if the day, month, and year are reasonably ascertainable from information in the testament as clarified by extrinsic evidence if necessary. Just write out the day of the month, put the day, and then put the whole year. That eliminates that problem. And then it says, there's two parts to this statute. That was all part A, this is part B. Additions and deletions on the testament may be given effect only if made by the hand of the testator. So I've seen it, if I've seen it once, I've seen it a million times. Somebody does their own handwritten will, and you know what, they come back a year later because Jim Bob made you mad. You scratch through Jim Bob's part and you write in something else. So that, I guess, is what the statute refers to as additions and deletions on the testament may be given effect only if made by the hand of the testator. I would say you're just asking for trouble by doing these scratch throughs and additions and deletions. It's just that they may be given effect if they're in your handwriting. So again, if you have an holographic testament and you change your mind about how you do something, just write a new holographic testament from the start. Don't do a bunch of scratch throughs. Don't get out the old liquid paper, and don't do the scratch through and then the initial where you initial it. That's an addition and deletion, and again, you're giving courts discretion. You're giving people an opportunity to challenge something. Just do a new one and get it right. All right, so that is just really part one of is a handwritten will valid? We've seen yes if you follow the validity requirements. However, should you have a handwritten will simply because you now know how to make it valid, or you now know how to make it legal? Maybe not, because you know it's a legal document. It has significant effect. The big problem with handwritten wills is you could leave out details that a well-written will, say that 5 times fast, well-written will, would include. I'll give you just an obvious example. It's a personal situation I dealt with many years ago. A lady had cancer. She knew her death was imminent, and she got a piece of paper out and she decided to write her own will. People do handwritten wills, I think, for two reasons. Number one, their death is imminent and they just don't have time to go to lawyers and do all that stuff. And then two, they fear the expense that lawyers will charge them, so they want to do the handwritten will, which to them doesn't cost anything. But problem is, it's yes, a handwritten will can be valid, but is it going to do the job? So the situation I'm talking about was years ago. A woman had cancer, unfortunately. She passed away. She had written her handwritten will, and then her surviving husband came into my office with the handwritten will, and I was sitting there looking at it. Did it meet the validity requirements of Louisiana? Yeah, it was all in her handwriting. It was dated. It was signed at the end. You know, she did it while she had good capacity. So it all met the validity requirements, but it said something to the effect of, regarding my home, I'd like my elderly mother to be able to live in my home for the rest of her lifetime. And then it went on a couple of sentences later, I want my husband to have my home. And then it went on a couple of sentences later to say, I certainly want my daughter to have a place to live while she's in college. so she should be able to live in the home as well. And so all three of them kind of said, well, the home is mine after the woman died. Wound up in court. Everybody had lawyers, lots of hearings, lots of legal expense, lots of briefs written. And so the judge had to determine whose name the home should be put into. It was a mess, all because of a hence legally valid will, but the will just didn't do the job from a substance standpoint. Had mom gotten some good advice, her will would have been written a different way to make it real clear, what rights she wanted her mother, her husband, her daughter to be able to have in that home after she passed away. So there you have it. Louisiana handwritten wills are valid if you meet the formality requirements, but be careful because one word written the wrong way while still a valid will could cause a lot of trouble with survivors and probably cause trouble with the people that you love and that you're leaving behind. So it's two parts. One, making sure it's valid, and then substantively making sure it does exactly what you want it to do for your survivors with the assets that you leave behind. I hope that helps. I'm Paul Rabalais. Have a great day. Make sure you like, comment, subscribe, all that good stuff. We'll see you.